Our first speaker of the plenary session is Mr. Charles CHIU. He is the chairperson of Guardianship Board. He has practiced law in Hong Kong over 20 years. Currently, he is also the member of the governing board of Havens of Hope Hospital and Haven of Hope Christian Service of Hong Kong. He will share with us the legal protections of rights of older people. Mr. CHIU, please.
Good morning, ladies and gentlemen. I must first of all thank Dr. Leung of this invitation, offering me this opportunity to speak almost for my last time in my official capacity as the chairman of the Hong Kong Guardianship Board before my upcoming retirement next January. This morning I will use the following 20 to 25 minutes to talk about legal protection of rights of older people of Hong Kong. My focus today will be on those older people lacking mental capacities. So I will roughly divide my presentation in 3 parts. First, we talk about adult guardianship, and then a High Court order known as the Part 2 order in Hong Kong. And then we look forward to the upcoming new horizon in Hong Kong in elder care, namely the continuing powers of attorney. So everything is upside down once the mental capacity of a person lapses. And this is an oil painting that I used to begin in most of my presentations. As you can see, the backdrop of this oil painting is about, it looks like a human brain. So the entire creation, i.e. the name of this oil painting, carry a special meaning. The world will be turned upside down once a person's mental capacity has problems. Adult Guardianship of Hong Kong. It has been launched in 1997, the year of the handover of sovereignty of Hong Kong to the motherland. The Guardianship Board's mission is to empower and to protect those elder persons who has lapses or deficits in their cognitive functions by means of a substitute decision-making model. So it is a best interest approach along the line of the United Kingdom. Annually, we have new applications at the range of about 250 cases per year. However, every case after guardianship order is granted, the board is required to review those cases before its term expiration. That is, you have to constantly review those cases. So it comes up with roughly about 550 to 600 hearings per year. So actually, we have to carry out kind of informal hearings at the Guardianship Board, like a tribunal. How we protect? This is one of the landmark cases in Hong Kong in my charge back about 11 years ago. I used to talk about this case a lot whenever I have the opportunity to present in the public. In this case, I will take you through very briefly the main features of this case. One day in a bank in Central, an elderly woman accompanied by a gang of 3 people to the counter requesting a transfer of funds of 7.5 million. You imagine, 11 years ago, 7.5 million Hong Kong dollars into a newly opened joint account with one of these people, these strangers. And the bank manager was very smart at that time, and then he held up everything, and then he called the police, and all these people were arrested. And this old lady, the subject person, was sent to QM Hospital, where he was assessed as a demented elder. In the course of social investigation, we note that this apparently looks like a family of three were actually strangers to this elder lady. And they met on the street about 2 or 3 months ago and talked about investments. And then the the concerned person was taken into the bank and transferred 3.5 million into the account of these people. And on the arrangement that those sums will be put into investments. And then a few weeks later, these three people bought a small check and visited the elderly at her home and presented to her that this small amount check was in fact the fruit of the investment. So buying in her trust. So 2 months later, that is on the day of the incident, they took the old lady to the bank, successfully persuaded her to transfer a larger sum of 7.5 million. So in the course of social investigation, we note that although this old lady was a retired secretary, but in fact, she has a sizable assets. Let me tell you how much. It's over 100 million cash, 110 million investments, and it's living in the mid-level flats worth a lot. So we held an emergency guardianship hearing and granted an emergency order to protect the old lady. And then police carry on their investigation. 1 year later, this old lady was, yes, I missed one important thing. We appoint the public guardian of Hong Kong, that is the director of social welfare. Now, at a review of the case 1 year later, we find out that she was only arranged to stay in an ordinary care attention home. So the board was not satisfied, and we pressed the director of social welfare to apply to High Court for a wider order so that the old lady could be sent or could be moved up to a quality care home. However, that hasn't been worked out, as the director thought that the amount of money was rather sufficient for the purpose at the time being. And then another year later, the matter took a turn. That is, we find out surprisingly that the old lady was diagnosed to suffer from liver cancer. And she has no money at the bank account of the public guardian to pay for expensive treatments. So we press ahead for emergency application to High Court for a wider financial power, which was finally done. And we, upon our repeated efforts, finally succeeded to arrange the old lady to receive private hospital services. That is, arranging a team of specialists, GI specialists, for the necessary liver surgery. And then she was recovering well and was arranged to stay in a top-notch private care attention home down the end of the Lam Long Hill Road. So as you can see, the function of the guardianship order, not only authorizing the guardian to have the power to go to bank and to withdraw the daily necessary expenses, but also we look into all the affairs of the subject person, not only finance, we look in medical treatments and welfare overall. And this is another case I won't have time to go into. And then we have another case which also was on the headline of the newspaper in Hong Kong. So now we have to briefly look at the profile of the Guardianship Board. Now, usually, the majority of cases came up to the Guardianship Board was for financial power, as you can see. more than 75%. However, we do have cases like family conflict, financial abuse, and other abuses. So this, we have a lot of varieties in the case nature in respect of the cases at the board. So the board was established in 1999, and where it came into operation is actually a tribunal. Whenever the tribunal sits, it requires members from 3 panels, from lawyer panel, from professional panel like social workers, doctors, and from the family panel, panel C, that is those persons or family carers who has the personal experience of having taken care of mentally incapacitated elders. Our procedures at the guardianship board is inquisitorial, informal, but we depend very much on the mandatory report from the social welfare department. So under this new law in 1997, the Part 4B of the Mental Health Ordinance, a new term came up called the MIP, Mentally Incapacitated Person. This is a term now commonly used in Hong Kong. And there are several legal criteria that must be satisfied before a guardianship order can be granted. The first, the mental or cognitive impairment must be of a substantial degree, and such impairment has limited the person's ability to make reasonable decisions. So it's a decisional capacity issue. Number 3, whether it is the last resort that guardianship order must be granted, because guardianship order touches the human rights or limits the human rights of that person. So this must be used as the last resort. So we always look for informal means, whether informal means can work to satisfy the particular outstanding need of that person. And then lastly, the 4th criteria is an overall assessment criteria, whether granting such an order is in the best interests of that person. So before an application is made, the applicant must know whether the order can enable the subject person's affairs be satisfied or be carried out. So the guardian power is very important to be noted. In Hong Kong, we only have 6 essential powers, only 6 very specific powers. A, to decide where the subject person should live. B, power to carry, to convey, to carry that person to a specified place for a good purpose. C, to require that person to attend a specified place for a good purpose. And D, that is the 4th criteria, is the 4th power. It is very important power. The power to consent to medical treatment, to consent to surgery, for example. E is the power to arrange us access to that person. Now that is an important power, but it is important to note that this access power is by no means a restrictive power. That is, the guardian cannot restrict someone to visit the subject person. It can only arrange someone to access or pay visit to that particular person. And then another very important power is the financial power, namely to hold, receive, and pay a monthly sum now currently set at 17,500 Hong Kong dollars. This changes every quarter, probably due to the inflation. So we have to look at the statistics from the government to ascertain this month, the exact amount of the monthly sum every 3 months. However, it is important to point out that this financial power is very restrictive. It is only confined to cash, that is savings at bank. So we have published a leaflet number 14 for the guidance of the public and professionals to make sure they understand this. So what about an elder who has properties, has investments at bank? So they need to use this tool. That is our second part, or the theme of our second part of today's presentation. That is a court order called the Part 2 order. So sometimes we call this committee order. This is a very old form of order, but it is very useful still today. This kind of committee order is rather cumbersome, unlike an guardianship application. It has to involve lawyers, high courts, official solicitor, and requires a lot of paperwork. It's very expensive, but it is useful. And in the year 2004, High Court gradually understand the importance to bridge the gap of this financial power. That is, apart from using the cash, a power in some form must be in place so that the assets of an elder person other than cash can be used. So High Court developed this practice direction number 30.1 in year 2005. This sets out the detailed procedures and steps to be taken when a solicitor is applying for such an order in High Court for their clients. I won't go into details about the operation of these type of order in the interest of time this morning, but just suffice to say that under Section 11, the court has the power to appoint such a committee. But the term itself is somewhat misleading because committee can be one person, okay? So take it as only a term, okay? This is a particular designation, namely, if I put it in a modern sense, it is only an alternative to the term called financial manager. It could be a family member, could be the official solicitor of Hong Kong, could be a trust company like Hong Kong Bank Trust, and could be a professional like a lawyer, like an accountant. So under 10b, the court has a very wide range of power to be entrusted, to entrust to a committee. All kinds of assets, all kinds of asset types and actions, transactions, and even executing a will for the mentally incapacitated person, and also power to carry on business, litigations, payment of any kind of debts, and they have, under Section 10D, emergency power like the Guardianship Board. High Court do have these emergency power orders. And the last bit of this part will touch upon statutory will. When a person lost his mental capacity, actually he cannot make a will for himself. But in High Court, under Part 2 of the Mental Health Ordinance, the court has the power to make a statutory will for the subject person, especially where there is potential conflict over the validity of the will, which may lead to diminution of the estate value of the subject in case the fight for the validity of the will finally came up to a legal battles. And so now we move on to the third part of today's presentation, which is the final part. In 1997, Hong Kong also passed the law of this very special type of powers of attorney called the enduring powers of attorney. As you know, everyone can make a conventional type of power of attorney to appoint someone to represent him, to do or to carry out transactions and do an act for himself. However, by common law back in 1879, this kind of ordinary powers of attorney will lapse automatically once the donor or the maker of the power of attorney has lapses in his mental capacity. That is, he becomes mentally incompetent. This is exactly the circumstances that a person needs someone to help him out. So we need a new law. So following the UK example, Hong Kong passes this Chapter 501 EPA Ordinance in 1997, specifying that this type of particular powers of attorney can continue to have effect even after the maker or the power of attorney becomes incapable mentally. However, this kind of EPA can only be used for taking care of the subject person's financial affairs and nothing else, nothing on medical, nothing on welfare decisions. And it must be in prescribed form. But the advantage of this type of advanced instrument is to allow the individual to exercise his human right to choose a particular person of his liking or whom he trusted to take on his affairs if anything happened to him. It avoids the various distresses in making court applications, in making application to the Guardianship Board and the waiting time, everything. And also, it is very cost effective. Imagine you make a Part 2 application nowadays, easily it will be spent 60,000 Hong Kong dollars in an application, easily. But this type of EPA, the legal costs, including the cost of doctors' witnesses, will be at the range of about $10,000. So it is very cost effective. However, since no one has been taking the responsibility of promoting this very useful tool, as you can see from this statistic graph, for the 14 years or even 15 years, 16 years, the usage rate was extremely, extremely low. So people of Hong Kong ask the question why. And the legal reform papers and find out that there are various discouraging factors to the use of this very special type of powers of attorney. The most problematic area is Section 5(2)(a), because it requires, whenever making this EPA, it requires a solicitor and a doctor to be the witness, who must be present at the same time. So it's a lot of cost involved and logistics involved. Eventually, the law was amended. However, the law was amended only to a small degree of relaxation. It only allowed these two professional witnesses to have a time gap between. They don't have to be present at the same time, but both of them must arrange a time to have both of them executed the same documents within 28 days. So one after the other. So usually it was signed before a doctor, and then within 28 days, it should be signed before a solicitor. So it's a slightly relaxed situation. So looking forward about advances in this type of advanced instrument in the year 2011, that is almost 9 years ago, there's a law reform report came out in Hong Kong recommending that the EPA regime should be extended from taking care of the finances of the subject person to include personal care. By personal care, it would mean health care as well. So this recommendation goes on to say that the future EPA should be reformed to include power for the attorney to decide where the donor lives, where or whom she should live with, and where she should work, to be educated or receive training, etc. And most important of all, this attorney will have the power to refuse or to restrict the access or contact to the maker of the power of attorney of specific individuals. And of course, most importantly, the power to make decision of health care, that is all kinds of medical consent. Now, this was a long in the long past, in the past 9 years, the government has been working hard to bringing about a new piece of legislation to reform this EPA. And the latest information is this: Hong Kong will no longer be able to execute new EPAs. There will be a new, entirely new regime called Continuing Powers of Attorney, that is the CPA regime. This new regime, together with its new name, will have new powers for the attorney. It covers everything. If I put it neatly, I would say this CPA will be equivalent, almost, to a self-appointment of a guardian, almost allowing an advance directive to be incorporated, almost to that effect. And as far as I know, the first draft of the draft bill, has come out in the year 2017, and that was for public consultation. But since then, the draft bill has been substantially revised. And I understand this new draft bill may, very likely, come up for consultation again very soon. So I wish that all those taking interest and concern in the elderly care will make substantial comments and insights when this new bill is really put up for public consultation in the near future. So that comes to end of my presentation, and thank you very much.